Registration ETC Act 2002 Amendment Bill 2022 HB 44 first reading taken. Leader of the Senate.
For hearing for first reading, bills even get to the level of second reading when they have not been sent to senators. As a matter of fact, yesterday we had to step down consideration of a bill because senators did not have enough time to go through it. If we have been complying with our rules, Mr. President.
What is your point of order, please? Go straight to the point of order.
All these bills that we are doing first reading have not been sent to distinguished senators as provided by our rules. I have not received a copy. I don't know if other senators have received copies. That's my point.
We stood down yesterday because of lack of circulation. We stood down the consideration of the report on the process of crime bill because the report was big, and also this is a very sensitive piece of legislation that we thought some of our colleagues here, the DSP, Senator Aleru and others, pointed out there was need for senators to read before we take the report today. So that was that. We didn't stand down the consideration of the bill because the bill was not circulated. But, Senate Leader, you should take note of this, please. The bills we are taking first reading should be circulated. Secretariat, we should circulate the bills to all our colleagues, please. If possible today. And if it is not possible, we should not be listing any bill that is not available. Thank you. Your point of order is sustained.
20I. Order 20I. Duties and functions of officers of the Senate. The Senate President, the President of the Senate shall, I, interpret the rules. Mr. President, you had interpreted the rule this morning on an order brought by fellow senator on Order 76, which you rightly agreed on and ruled rightly that the leader should comply with the rules. And just now, the leader is now trying to bring the same bill for which he has not complied with the rules. So I suggest that the leader step down this bill until he complies with the rules in Order 76 as you have ruled.
Instead of trying to usurp that role from where you are sitting, you did not set the tone rightly. The point of order raised by Senator Binozi Arododa was on the first reading of the bills in our order paper. And I sustain his point of order, and I said the leader and the secretary should provide the bills. That is not to be taken all over the business of the day. So on this one, we know that we receive a letter, and the letter is categorical, indicating that the executive wants an amendment to Section 84, subsection 12 of the newly signed Electoral Act 2022. And that is something that we all know, and this debate on the second reading to be led by the leader, in my judgment, should continue. It's for you to make your point of view known, whether you support the call for the amendment or you don't. But on this, we cannot go back to what we did earlier. that is to say, distribute the bills. I still maintain that we must continue to have the bills distributed to us, but this is one item that we had a letter circulated. So I rule that the leader should lead the debate, and then distinguished colleagues, we all know what 84 subsection 12 is. And I think this is something that we can handle. Thank you. Point of order, Senator Ali. Okay, go ahead.
Reference should not be made to any matter on which a judicial decision is pending in such a way as might, in the opinion of the President of the Senate, prejudice the interest of the parties.
I want to clarify what I said yesterday so that we understand my reasoning, because that was my understanding. The fact that the court said the National Assembly should not tamper with law, the Electoral Act 2022, as amended, except through due process, does not mean that the National Assembly cannot consider the bill. It doesn't mean. And we have our own due process. And I said the President was within his competence to request for amendment. In fact, any Nigerian could ask for an amendment to any law, including the Constitution. And the National Assembly can consider such request appropriately. So for us to be specific to this particular request, the request was duly done, and for us in the Senate is to look at the request, follow our due process. Looking at the request does not mean granting the request. It's not in any way saying granting the request. Members of the National Assembly are at liberty to review the request, see if the arguments by the executive arm of government are convincing enough. If the arguments are not convincing enough, members of the National Assembly could deny the request. And that is how it is. And why I ruled that way was because we have no encumbrance from that order. No encumbrance at all. Because even the judge himself said we follow due process. And our due process, we had first reading yesterday. Today, the second day, we are taking the second reading of the debate. And it's for senators here to decide to vote for this amendment or vote against it. So I think we are not breaching any law. In fact, we are trying to promote democracy by doing this. Because to do otherwise, one day, someone will go to court and say that the Senate or the National Assembly should not sit. So I want to please appeal to all of us that we are on the right course, and my ruling remains that we are going ahead to consider the proposal, the request, which the leader of the Senate is leading the debate. And at the end of the debate, we are going to vote. And the vote decides the fate of the bill. And I'm sure all of us know that whatever we'll do here is to protect this, the democracy and the sanctity of this chamber. I have nothing personal. What you want is what I go with. Senate Leader.
Lead the debate on this very important bill which seeks to amend Section 84 of the Electoral Act by deleting subsection 12. The bill was read the first time in this chamber yesterday, 8 March 2022. You may recall that the bill was passed into law and was assented by the President Commander-in-Chief on the 26th of February 2022, however, of candidates for any election. The above clause was interpreted as being in conflict with extant constitutional provisions to the extent that it disenfranchises serving political office holders from voting or being voted for at conventions or congresses of any political party for the purpose of the nomination of candidates for any election in cases where it holds earlier than 30 days to the national election. Mr. President, distinguished colleagues, this provision has been interpreted by the executive arm of government as introducing qualification and disqualification criteria that are ultra-violating the Constitution by way of importing blanket restriction and disqualification to serving political office holders. Mr. President, distinguished colleagues, you will recall that the Electoral Act was extensively debated here, and it is my humble position that this proposed amendment be looked into by this distinguished Senate, which can come out with an objective position that will strengthen our electoral processes as well as democratic dispensation or disposition. I therefore call on my distinguished colleagues to consider this proposal on its merit or demerit and support the second reading of this bill so that we can invite it to the relevant committee for further legislative action. I so submit.
Minority Leader.
Thank you, Mr. My name is Yahaya Abdullahi. I represent Abia South. Mr. President, sometimes matters come to this floor, and when those matters come, we treat them in the best possible way to deepen democracy and enhance our constitutional conditions that we are all elected for. Mr. President, distinguished colleagues, there are certain things that we see which we think we don't even have to come here to debate. One of those things is the fact that in every democracy all over the world, there are certain rules which we don't need to be told about. Yes. And one of those rules is the fact that you cannot be a referee and a player in the same field. It's either you're a referee or you're a player. So, anywhere else in the world where democracy is properly practiced, like in Nigeria, we don't need to be told that if we want to run for office and we are appointed into an office, that we have to resign. That is a sine qua non that we don't even need to debate. Yet, here we are today in Nigeria, and people think that they can sit in an office and contest an election and become candidates and continue to sit in that office until the date of election. So how would we continue to debate democracy in this way? So, Mr. President, I think that merely looking at this and somebody, a cursory look on this paper shows that this paper is dead on arrival. And I urge you, my colleagues, to help us to continue to deepen democracy by insisting that this bill not be read a second time in any manner whatsoever. I so submit.
Yeah. And indeed, Mr. President, it's a settled matter in law that you cannot be a judge over your own case. In any election, Mr. President, where people have the added advantage of holding executive power, either by proxy or directly, either by appointment, and for such people to have access to compete with others who came from the streets. I think it's an unjust society. Therefore, Mr. President, I disagree with all the arguments emanating from your table on the need to reconsider a decision that already been settled. Mr. President, once again...
I think I will stop you at this point because that the lead debate was read by the Senate leader. No. And just hold on. You will still speak. You haven't finished. The lead debate was delivered by the Senate leader, and rightly so, because the Senate leader, by way of information, is in charge of government business here. What I did my comments, my remarks, were what gave you the opportunity to be speaking now on this thing. Because initially, there was a point of order where we should not even talk about it. And I thought that is not the way to go. That we should talk about it in a very conclusive way. So you have the opportunity now to speak. And of course, just like the minority leader said, that there was no need to even talk about it. I wonder how people would have had his position if there was no need to speak. You can now conclude.
Because those days we were in the struggle together.
Thank you. That looks more like it.
And I'm not in that way. I see very much in the struggle together, Mr. President. On a serious note, Mr. President, I think from the reaction of colleagues, the only option we have is for you to put the question and you get the response.
I am not from the executive as alluded to by the PDP. Mr. President, let me start with this cliche. What is right is not always popular. And what is popular is not always right. Mr. President, following our elections, we were sworn into office. On being sworn into office, Mr. President, we swore to protect and defend the Constitution of the Federal Republic of Nigeria. Mr. President, that Constitution, the 1999 Constitution, Mr. President, was put together by the best brains. 50 of them, Mr. President, were nominated to put together this Constitution. At the end of the day, Chief Obafemi Awolowo at the time, in his own wisdom,
DSP, I will suggest other colleagues to speak also.
Laid to rest. Let me have my say. The point I'm making, Mr. President, is that the framers of this Constitution, they knew that a day like this will come. And notwithstanding, they clearly stipulated in the Constitution those provisions dealing with qualification and disqualification from running for political office. If it was their intent, Mr. President, that for holding a political office, you should not contest election, they would have so provided. Mr. President, I do not believe. Mr. President, I have the floor. Mr. President, I have the floor.
DSP, you can round up, please.
I've not finished.
DSP, please finish this thing.
The Electoral Act. There was a provision some of us fought for. And the provision, I believe, is also at the beginning of Section 84, that says that no political party shall seek to disqualify anybody by importing into the process a provision for qualification or disqualification not otherwise provided for in the Constitution. It is there at the beginning. I believe that's Section 84, Section 84.2. Mr. President, Mr. President, I therefore rise to support the motion as moved by the Senate leader, that we allow this very bill to go to second reading. I so move. Thank you.
Distinguished colleagues, I will put the question. I've listened enough, so I will put the question, and every one of us is at liberty to vote his conscience. Those in favor that this bill be now read a second time, say aye. No, maybe you didn't hear me. No. Leader, maybe you didn't hear me. I think I will be more audible now. Those in favor that this bill be now read a second time, say aye. Those against, say nay. You didn't hear me? No, I'm not putting the question again because I put the question, there was an aye and there were nays. And I said the nays had it.